What just happened in the RICO lawsuit, and why it matters. On August 1, 2025, a Pennsylvania appellate court quietly dropped a bombshell. It dismissed, in full, the appeal that had been hanging over content creators Jessica Granny's Watching Sang and her co-defendant Barbecue Lady. Here's what that means, how it happened, and what comes next. How we got here. Last April, a trial-level judge in Delaware County granted an anti-SLAPP motion filed by Jess and Barbecue Lady. Anti-SLAPP laws let you stop a flimsy lawsuit that's really meant to silence free speech. The plaintiffs, 9 social media personalities plus TV bounty hunter Dwayne "Dog" Chapman, didn't take the hint. They filed an appeal with Pennsylvania's Superior Court, hoping to revive claims ranging from RICO racketeering to defamation. The fatal filing. Appeals have homework. Rule 3517 requires a one-page docketing statement, a simple roadmap telling the clerk what the case is about. The plaintiffs missed the 21-day deadline. They ignored Jess's motion to quash, and they asked for yet another extension on their merits brief. 3 appellate judges looked at the file and said, "Enough." Friday's order, translated. On the record, the court wrote, "The application is granted. The appeal is dismissed for failure to file a docketing statement." In plain English, you broke a mandatory rule, you didn't fix it, and now the case is over. The anti-SLAPP win from April is final, and control snaps back to the trial judge, the Honorable Kelly Eckel. What happens now? Fees and punitive damages. Jess's lawyer will file a detailed fee petition. The judge can also grant punitive damages, extra money meant to punish litigation abuse. Back in April she wrote, "Not at this time," leaving the door wide open for exactly this moment. Mandatory court date. The original plaintiffs must appear in Pennsylvania for the fee and damages hearing, or risk contempt. Slim odds on a second appeal. They could beg the Pennsylvania Supreme Court to revive the case, but that court rarely rescues parties who ignore Rule 3517. The Oklahoma sideshow. One plaintiff filed a fresh suit in Oklahoma while the appeal was pending. Now that the PA case is final, Jess's team will ask the Oklahoma court to toss it on jurisdiction grounds and may file a brand new anti-SLAPP counterclaim there too. Why it matters. Procedural rules aren't technicalities. Miss a mandatory filing, lose your appeal. Anti-SLAPP has real teeth. Plaintiffs can end up paying both sides' lawyers, as this group is about to learn. Copycat lawsuits backfire. Refiling the same claims in a new state is classic abuse of process and triggers another round of fee shifting. Free speech survives. The very law meant to protect commentary about a missing child case has now withstood its first appellate test in Pennsylvania. The bigger picture. Lost beneath all the litigation is 15-year-old Sebastian Rogers, the child whose disappearance sparked the online coverage in the first place. Friday's decision frees the defendants to refocus on that search, while it sends a clear signal to would-be plaintiffs. Weaponizing the courts to silence critics is expensive, risky, and, at least in Pennsylvania, likely to boomerang. For Jess and Barbecue Lady, the appeal is done, the damages phase begins. For everyone else, it's a reminder: follow the rules, respect free speech, and keep the real story, Sebastian's story, front and center. What Friday's dismissal means for Britney Jackson. The appeal is gone. Jess Granny's Watching keeps her anti-SLAPP victory, and the case drops back to the trial judge. So, what does that do to plaintiff Britney Jackson? 7 concrete things. She is now a judgment stage defendant. With the appeal dismissed, Judge Kelly Eckel regains jurisdiction. Britney must appear, personally, at the upcoming fee and damages hearing, or risk a contempt warrant. Money gets real. Anti-SLAPP shifts the entire defense bill to the losers. Jess's lawyers will file a line-item invoice. 6 figures is common, punitive damages could push the total higher. If Britney can't pay, defendants may garnish wages, freeze bank accounts, or lien property. No do-over in Pennsylvania. RICO and 42 other claims were dismissed with prejudice. Friday's order locks that in. Functionally, Britney can never refile those counts in Pennsylvania. Out-of-state lawsuits will backfire. A co-plaintiff already tried Oklahoma. Now that PA is final, any clone suit faces easy dismissal, and a fresh anti-SLAPP counterclaim. Translation: another court, another round of defense fees Britney would have to pay. Her own lawyer is exposed. The dismissal cites counsel's failure to file a docketing statement. That lapse invites malpractice or bar discipline trouble. Costly sideshows Britney would still have to fund while owing Jess's judgment. Online posture can raise the bill. Every stream that repeats false claims now counts as post-filing malice. The judge may use it to justify a larger punitive award, and the platforms could treat it as harassment content. Smart exit ramp. Hire new counsel for the damages phase. Negotiate a payment plan before the hearing. Publish a short, accurate correction to stop the punitive meter from running. Ignoring the problem means a judgment that accrues interest for 20 years, and follows her across state lines. Bottom line, Friday didn't just end the appeal, it flipped Britney's risk from maybe we win to how much will we owe. The longer she waits, the larger that number gets. Advice for Britney moving forward. 1. Hire fresh counsel now. Why? Your current lawyer's missed filing cost you the appeal, you're about to enter the fee and punitive phase. Look for a Pennsylvania civil litigation specialist with recent anti-SLAPP experience. Someone not personally tied to the original plaintiffs group chat dynamic. First task, audit the case file, calculate realistic exposure, and open settlement dialogue before the fee hearing is scheduled. 2. Pivot from offense to damage control. Stop new lawsuits. Every fresh filing adds defense bills you'll have to pay if you lose. Quit streaming about the defendants. Post-judgment malice can inflate punitive damages. Wipe provably false statements. A quick correction log on your channel shows good faith and can soften the judge's view. 3. Get ready for the money conversation. Gather finances, tax returns, pay stubs, assets, debts. You may need them for a payment plan proposal. Expect 6 figures. Anti-SLAPP fee awards routinely cover all hours the winner's lawyers spend, from first complaint through the quashed appeal. Talk to a bankruptcy attorney, just in case. Knowing the Chapter 7/Chapter 13 options ahead of time reduces panic later, and sometimes strengthens settlement leverage. 4. Protect essential income streams. Separate personal and channel revenue. Use an LLC bank account so garnishments don't freeze rent or grocery money. Diversify platforms. If YouTube ever demonetizes for harassment content, you'll want a fallback: Patreon, Substack, consulting work, anything not tied to the lawsuit. Document legitimate business expenses. Courts can seize net profits, but ordinary operating costs are deductible. 5. Reframe your public message. Acknowledge the ruling accurately. The appeal was dismissed, the lower court order stands. I'm addressing the fee phase with counsel. Drop the courtroom bravado. Viewers donate less when they sense overconfidence, they respect transparency about risk and next steps. Refocus on content, not combat. Cover cases you aren't personally entangled in, let the legal story live in short, factual updates. 6. Safeguard your mental bandwidth. Mute keywords and block trolls. Doom-scrolling court commentary only fuels bad decisions. Schedule an off-screen routine. Exercise, therapy, faith community, whatever keeps you grounded. Create a crisis buddy system. One person you call before tweeting or streaming angry. 7. Remember the bigger win condition. The point now isn't to beat Jess, it's to walk away with A. Your livelihood intact and B. No lingering judgment that snowballs interest for 20 years. That happens fastest when you take the L on the appeal. Negotiate a number you can actually pay. Move on, publicly and privately. Handle that, and the story eventually becomes expensive lesson learned, not permanent financial albatross. Hope this information was helpful.